Hello, hope you all are doing well. Today, myself Manpreet Singh and my all four friends Inderjeet Singh, Sahil Preet Singh, Mehakpreet Singh, and Harsh Soha. We all five are working on the group case law assignment, which is based on several facts, issues, holdings, and some of rationals. Now let's start with the case. Name of the case is Gilbert Steels Limited versus University Construction Limited, 1976, Canal 2nd 672. It is basically between two parties in which plaintiff is Gilbert Steels Limited, which is the supplier of steels material who sought to enforce the increased price for steel under a modified agreement. On the other side, there is a defendant, which is University Construction Limited, the purchaser of the steel materials, who initially agreed to the increased price but later refused to pay, also claiming the agreement was an unenforceable. Now it's time to begin with introduction of the case. So the case Gilbert Steels Limited versus University Construction Limited is a pivotal Canadian contract law case that examines the doctrine of consideration and contract modifications. Decided by the Ontario Court of Appeal, it concerns the enforceability of a verbal agreement to amend an existing contract without fresh consideration. Gilbert Steel, a steel supplier, sought a price increase due to the market changes, and University Construction, on the other side, who's the buyer, verbally agreed without receiving any additional benefit. When University Construction later refused to pay the increased price, Gilbert Steel sued, arguing the verbal agreement was binding. That's all about the introduction of this case.
Hello, Professor. My name is Inderjeet Singh, and I am going to talk about the factual events of this case. So, the plaintiff Gilbert Steel Limited entered into a written contract with the defendant University Construction Limited to supply a steel at a fixed cost for the three building projects. So, this includes steel for the university project, consisting of two buildings. Before the first building for the university project began construction, Gilbert Steel announced a price increase for steel on October 22, 1969. The parties negotiated a new written contract that reflect the increased price for steel supplied for the first building. On March 1970, the parties reached an oral agreement to reflect this second price increase for the steel supplied for the first building. Let's talk about the facts of this case in detail. So, on October 4, 1969, the plaintiff Gilbert Steel Limited and the defendant University Construction Limited entered into a written agreement for the supply of steel at a fixed price for three building projects. Among these was the university project, which involved constructing two buildings. Before work began on the first university building, Gilbert Steel announced a price increase on October 22, 1969. As I earlier mentioned, the parties agreed to a new written contract that incorporated the high price for the first building. So let's talk about another fact. While construction on the first building was still underway, Gilbert Steel announced another price increase on March 1, 1970. The parties reached an oral agreement to reflect this second price increase. Following this, Gilbert Steel sent a written contract to the defendant to formalize the update terms, but the defendant never signed it. So the defendant continued to accept the deliveries of the steel, but failed to make the full payments against the invoice reflecting the second price increase. The plaintiff sued for a breach of contract for the balance owing. The trial judge dismissed the plaintiff's claim and the plaintiff appealed.
Hello everyone, my name is Harsh Saroha and I am here to speak on issue of this case. So specifically, did the oral agreement between the plaintiff Gilbert Steel and the defendant University Construction constitute a valid and binding modification of their existing contract? And the second point is, could the second price increase be enforced when there was no fresh consideration provided by plaintiff for the modification of the original contract terms? Could the defendant continued acceptance of steel by interpreted an acknowledgement and acceptance of the higher provider? was the lack of execution of the written contract formalizing the March 1 oral agreement relevant in determining whether the second price increase was legally binding. The holdings of this Gilbert Steel Ltd University Construction Ltd case is a flaw, and here is the points. The Ontario Court of Appeal upheld trial judge decision, ruling the plaintiff claims for the second price increase was not enforceable. The court determined that the oral agreement to the second price increase lacked fresh consideration because the plaintiff was already obliged under the original contract to supply steels and the agreed upon price. Without additional consideration from the plaintiff, agreement modifying the price was legally unenforceable. The defendant continued acceptance of steel deliveries did not constitute implicit acceptance of the second price increase because there was no clear evidence of mutual intention to be legally bound by the revised terms. Thank you.
Hi, my name is Harpreet Singh. I am here to discuss about the rationale of case. The court highlighted that in the order for a contract modification to be deemed legal, one party must offer a new benefit or obligation in exchange for the modified conditions. For the second price hike, Gilbert Steel only carried out its pre-existing duty to supply steel. It did not offer anything new in return. The case justification performing a obligation that one is already required to fulfill cannot be used as a legitimate consideration for changing a contract. According to the pre-existing duty rule on March 1, 1970, the parties verbally agreed to the second price increase. However, because consideration was not included, the agreement lacked the legal components required to be enforceable. Moreover, Gilbert Steel contended that acceptance of the revised price was inferred by University Construction's continuous acceptance of steel supplies following the oral agreement. The court ruled, however, that merely accepting the products did not amount to and explicit approval of the price hike. If the defendant had believed that the original contract price still applied, they might have accepted the delivery. Gilbert Steel contended that acceptance of the revised price was inferred by University Construction's continuous acceptance of steel supplies following the oral agreement. The court ruled, however, that merely accepting the products did not amount to unambiguous and explicit approval of the price hike. If the defendant had believed that the original contract price still applied, they might have accepted the delivery.
Hello, a very good morning to all of you. My name is Mahkpreet Singh. Today I am here to discuss about my topic conclusion. The Court of Appeal concluded that Gilbert Steel was not entitled to the balance of the invoices reflecting the second price increase as the oral agreement for the price change lacked fresh consideration, making it enforceable. The court applied the pre-existing duty rule, determining that continue to apply steel under the original contract did not provide valid consideration for the modification. Furthermore, that the defendant acceptance of steel deliveries did not imply acceptance of the new price, and the failure to execute the written contract formalizing the price increase further weakened the forcibility of the revised terms. Thus, the court dismissal of the plaintiff's claim was upheld. Thank you and have a great day.